You are listening to KSG podcast. This is a short, crisp, concise, exam-oriented, edited editorial for civil services aspirants. In this podcast, we are going to talk about amendments to the Cooperative Societies Act. Source for the content is Harikishan Sharma's article for the Indian Express. The Lok Sabha on 20th of December 2022 referred the Multi-State Co-operative Societies Amendment Bill 2022 to a joint committee of Parliament. The bill was introduced on 7th of December 2022 when opposition members argued that it seeks to take away state governments' rights and demanded that it be sent to the standing committee. The bill is aimed at overhauling the existing law, which was enacted 20 years ago. But first, what is a cooperative society and who governs them presently? Cooperatives are organizations formed at the grassroots level by people to harness the power of collective bargaining in the marketplace. This can mean different kinds of arrangements, such as using a common resource or sharing capital to derive a common gain that would otherwise be difficult for an individual producer to get. In agriculture, cooperative dairies, sugar mills, spinning mills, etc., are formed with the pooled resources of farmers who wish to process their produce. Amul is perhaps the best known cooperative society in India, but the numbers show their prevalence. There are nearly 2 lakh cooperative dairy societies and 330 cooperative sugar mill operations across the country. Cooperatives are a state subject under the constitution, meaning they come under the state government's jurisdiction. But there are many societies whose members and areas of operation are spread across more than one state. For example, most sugar mills along the districts on the Karnataka Maharashtra border procure cane from both states. The existing law, the Multi-State Co-operative Societies Act (MSCS) of 2002, was enacted by the then Atal Bihari Vajpayee government for managing them. Cooperatives of more than one state are registered under the MSCS Act. Their board of directors has representation from all states they operate in. Administrative and financial control of these societies is within the Administrative and financial control of these societies is with the central registrar, with the law making it clear that no state government official can wield any control over them. Now, why amend the existing law? The Multi State Cooperative Societies Amendment Bill 2022, piloted by Home and Cooperation Minister Amit Shah, was introduced by his deputy B.L. Verma in Lok Sabha. Since 2002, many changes have taken place in the field of cooperatives. At that time, cooperation was a department under the Ministry of Agriculture. However, on the 6th of July 2021, the government carved out a separate cooperation ministry and Shah became the first cooperation minister of the country. Soon after taking charge of the ministry, he announced the bringing in of a new national cooperative policy. The statement of objects and reasons of the bill said the Multi-State Cooperative Societies Act 2002 was enacted to consolidate and amend the law relating to cooperative societies with objects not confined to one state and serving the interests of members in more than one state to facilitate the voluntary formation and democratic functioning of cooperatives as people's institutions based on self help and mutual aid, and to enable them to promote their economic and social betterment and to provide functional autonomy and for matters connected therewith or incidental thereto. It added that Part 9b was inserted in the Constitution, vides the Constitution Act 2011. In view of insertion of the said part, it has become imperative to amend the Act. Further, developments over the years also necessitated required changes in the Act so as to strengthen the cooperative movement in the multi-state cooperative societies. Now, let's talk about the new rules for merger. The bill provides for the merger of any cooperative society into an existing multi state cooperative society. Any cooperative society may, by a resolution passed by majority of not less than two-thirds of the members present and voting at a general meeting of such society, decide to merge into an existing multi state cooperative society. It read, at present, only multi state cooperative societies can amalgamate themselves and form a new multi state cooperative society. Now, talking about cooperative election authority, also the bill seeks to establish a cooperative election authority with a view to bring electoral reforms in the cooperative sector. As per the proposed amendment, the authority shall consist of a chairperson, a vice chairperson, and members not exceeding three to be appointed by the centre. Now, who can be appointed the chairperson of the authority? As per the proposed amendments, a person shall not be qualified for appointment as chairperson of the authority unless he has held the post of additional secretary to the Government of India or equivalent rank, vice chairperson of the authority unless he held the post of joint secretary to the Government of India or equivalent rank, and member unless he fulfills such qualification and experience as may be prescribed. The chairperson, vice chairperson, or member of the authority will hold office for 3 3 years or until they attain the age of 65 years, whichever is earlier, and they shall be eligible for reappointment according to the proposed Section 45(4). Now, what was the Constitution Act 2011? Through the 97th Constitutional Amendment, Part 9b was inserted into the Constitution. The right to form cooperative societies was included as right to freedom under Article 19, Part 1, Part 3 of the Constitution. In addition to this, Article 43b was also inserted as one of the directive principles of state policy under Part 4 of the Constitution of India. Now, Clause 37 of the bill seeks to amend Section 104 of the Act to increase the amount of penalty for certain offences. The proposed subsection 6 of the Section 104 of the Principal Act says, where the board of directors or officers of the multi-state cooperative society receive any unlawful gains while transacting matters related to such society or utilize any assets of the society for personal unlawful gains, such directors or officers concerned shall be punishable with imprisonment for a term which shall not be less than 1 month, but which may extend to 1 year, or with fine which shall not be less than 5,000 rupees but may extend to 1 lakh rupees, or with both, and the proceeds of such unlawful gains shall be recovered from them and deposited in such manner as may be prescribed. Now, talking about the ombudsman having the powers like civil court. The government has proposed to insert a new chapter 9A relating to redressal of complaints. Under this new chapter, the government has proposed to appoint one more cooperative ombudsman with a territorial jurisdiction for inquiring into the complaints made by the members. For this, a new Section 85 will be added to the law. The complaints can be made by any member of the multi-state cooperative societies regarding their deposits, equitable benefits of society's functioning, or any other issue affecting the individual rights of the concerned member in such manner as may be prescribed. The proposed Section 85A(1) said, according to the proposed amendments, the cooperative ombudsman shall, on receipt of a complaint, complete the process of inquiry and adjudicate within 3 months. The ombudsman may issue necessary directions to the society during the course of inquiry, and the society shall be bound to comply with the same within a period of 1 month. As per the proposed provisions, a multi-state cooperative society can appeal an ombudsman decision within 1 month before the central registrar, who shall decide on it within 45 days. The central registrar may entertain the appeal after the expiry of a month if he is satisfied that the society was prevented by sufficient cause from preferring the appeal in time. The cooperative ombudsman will have the power of civil court in summoning an examination. Now, talking about the fund for the revival of sick cooperative societies, the bill also seeks to insert a new Section 63A in the Principal Act relating to the establishment of the Cooperative Rehabilitation, Reconstruction and Development Fund for revival of sick multi-state cooperative societies. It also proposes to insert a new Section 78 relating to concurrent audit for multi-state cooperative societies having an annual turnover or deposit of more than the amount as determined by the central government. The Centre has also proposed to make provisions for appointment of a cooperative information officer to provide information relating to affairs and management of the multi-state cooperative society to the members of such society. Now, talking about cooperative societies as state subjects, some of the opposition's objections to the Centre's bill were based on the fact that cooperative societies are a state subject. The subject cooperative societies is mentioned in the entry 32 of the state list under the 7th schedule of the Constitution. According to the entry 32 of the state list, incorporation, regulation, and binding up of corporations other than those specified in List 1 and universities, unincorporated trading, literary, scientific, religious, and other societies and associations, cooperative societies. Now, besides, entry 43 of the central list under the 7th schedule of the Constitution also makes clear that cooperative societies do not come in Centre's domain. Incorporation, regulation, and winding up of trading corporations, including banking, insurance, and financial corporations, but not including cooperative societies, states entry 43 of the central list. That's it for this podcast. Thank you so much for listening. To join KSG India courses and to crack the IELTS exam, visit ksgindia.com. You can also get a PDF of this podcast on ksgindia.com.